I really need to do this video. It's on compelling state's interest. If you're in a Texas family court, this video is for you. My name is George Saldana. I'm a Harris County Family Court veteran. I've been in the Harris County Family Courts here in the state of Texas for the last 8 years. I really want to talk about the compelling state's interest. It's something I think we're missing out on, especially if you're in a Texas family court and you're fighting to see your children. Have you seen this picture? And let me just read it to you. The Due Process Clause does not permit a state to infringe on the fundamental rights of parents to make a child rearing decisions simply because a state judge believes a better decision could be made. Troxel versus Gronville, Justice Sandra Day O'Connor. So I changed my perspective and I thought about this. So when can the state be permitted to infringe on fundamental rights of parents making child rearing decisions? And that's when I came up with the compelling state's interest. So let's talk about it. So I did some research. A compelling state's interest is a legal standard used in constitutional law to justify government actions that would otherwise infringe upon fundamental rights. It refers to a government interest of the highest order, one that is essential or necessary to achieving a critical public goal, such as protecting public safety, national security, or individual rights. Under strict scrutiny, the highest level of judicial review, a law or government action that burdens a fundamental right, such as free speech, due process, or equal protection, it must serve a compelling state's interest. The government must demonstrate that its objective is of significant importance. 2, be narrowly tailored. The law or policy must specifically designed to achieve the interest without unnecessary overreach. 3, use the least restrictive means. There must be no legal restrictive alternative available to achieve the same goal. Courts have recognized compelling interest in cases involving national security, preventing discrimination, protecting children, and ensuring a fair judicial system. However, a government's claim of compelling interest is not automatically accepted. It must withstand judicial scrutiny. So what does this all mean? So let me break it down for the normal layman in family court. In family courts, a compelling state interest means government, through the court, a judge, can limit a parent's rights only if it has very important reason. One that is necessary to protect a child's safety, well-being, or best interest. For example, the court can limit parental rights if there is evidence of abuse, neglect, or serious harm to the child. The court can order supervised visitation if it believes a parent poses a risk but still has a right to see their child. The state can remove parental rights only in extreme cases where the child's safety is in danger. However, the court must prove that its decision is truly necessary and that there is no less extreme option that would still protect the child. Courts cannot take away rights just because a judge personally disagrees with a parent's choices. It has to be based on strong evidence of law. Did you get all of that? Lot to digest, but let me just break it down to you in George terms. Basically, what it's saying is the state has a burden to prove when they limit your fundamental rights to your child. A lot of parents go into family court and they already say, well, my constitutional rights are being violated. The way these courts are violating your fundamental right is through a compelling state's interest. If someone makes a claim of abuse, neglect, if an attorney interjects words into your pleadings to trigger a compelling state's interest, okay, all of that is wrong. All of that is wrong. We need to start challenging the compelling state's interest anytime the state or a judge or your ex wants to try to limit your fundamental right to your child. whether it's through educational, medical, or possession and access. I think honestly, we need to start challenging the compelling state's interest in a lot of family law cases. It's not being done right now. All I'm seeing is cookie cutter litigation in our Texas family courts. And I think it's something we should be trying. We should be attacking the compelling state's interest anytime a judge wants to limit our fundamental rights to our child. Take it or leave it for what it's worth. It's just a tool to add to your toolbox. I encourage you to research it. I want to do a more thorough video later, but I had to really do this video to get it off my chest. Thanks for watching, and let me know what you think in the comments below.